Well, good afternoon. Thank you for joining us on this Byram Street Chambers webinar on interim payment strategy and high value cases. It's 4 o'clock, and I guess we should think about starting in a few moments. I can see people are still joining on, so we'll give a couple of minutes or a few moments anyway before we start.
Recording in progress.
Okay, so as I said, welcome. Thank you for joining us. And in case you didn't guess, my name's Michael Lemmy. Well, Mike to those that know me. Before we delve into this subject, could I say special thanks to Megan for helping me with the logistics in this case. And some of you may have noticed that on the chat box, if you click that, you'll see that Megan's posted this PowerPoint presentation. You can download it and you'll have it for reference purposes should you need to refer back to any of the cases that I'm going to talk about. So the first slide I've put up is really headlining what this talk is about: strategy, tactics, and arguments. According to Steve Jobs, strategy is figuring out what not to do. And my immediate thought was, well, by attending a 4 p.m. webinar, we may all have failed this test at the first hurdle. So some of the things we're going to look at are who to pursue. That's the simple sort of issue in this case. In case of multiple defendants, it becomes a little bit more complex. We're going to look at their insurance status. We're going to look at what evidence to deploy, whether that's by way of a schedule, a counter schedule, a witness statement, medical expert evidence, non-medical expert evidence. I want you to think about what form that evidence should take, whether it's a pleading or a document or a letter or a Part 35 compliant medical report. I want you to think about whether there's a genuine dispute or a substantial challenge to causation, whether that can only be determined after trial, or are there issues that are capable of being determined at the interim payment application stage? Are there genuine disputes on contributing negligence that you can raise or that might be raised by the defendant? Are they capable of being determined or not? I want you to have a think about the arguments on valuation, remembering always to take a conservative approach. And I want you to have a think about what arguments are available and how we treat special damages between assessment and trial. And we're going to touch on, and I want you to think about during the course of this talk, about the level playing field and prejudice arguments and the treatment of future losses and need. So there's lots of things to think about, and rather than just draw those threads out at the end, I've put them up there at the beginning. You can think about them as we go through some of these slides. Now, I'm not going to take you through CPR 25.6 and 25.7 at great length. 25.6 just deals with the general procedure. Applications must be supported by evidence, and I don't propose to say any more about that at this stage. 25.7 is where the rule starts to get more interesting, and obviously the first two conditions here, 1A and B, are straightforward, and we don't really have to say much more about those. But let's move on to the next condition, 25.71C. So the court may make an order for an interim payment if satisfied that if the claim went to trial, the claimant would obtain judgment for a substantial amount of money against the defendant from whom he's seeking an order. We've got the case of HMRC and GKN, and we've got to consider what would obtain judgment means. And we've got some guidance in this case. It means that the court must be satisfied that if the claim were to go to trial, then on the material before the judge at the time of the application, the claimant would actually succeed in his claim. And furthermore, that as a result, he would actually obtain a substantial amount of money. The court has to be so satisfied on a balance of probabilities. And various other cases have considered what HMRC and GKN means and repeatedly say it's not enough to say that C is likely to succeed. You've got to be satisfied that C would succeed. So what does that mean? On the balance of probabilities, C will or would obtain a judgment. If on the balance of probabilities you will obtain judgment, i.e. there's a 51% chance you will obtain judgment, isn't that the same as saying C is likely to succeed? So I find that's a confusing passage. I think that what you're not allowed to do is to say on the balance of probabilities, C is likely to obtain judgment, because that's saying he's probably going to succeed. And you can't do that. That would be something much less than 50%. But what you can say is on the balance of probabilities, C will obtain judgment. CPR 25.71E is a little bit more complicated than that. So I've set it out there for you. It's involving a case where there's two or more defendants and you're seeking an order against any one or more of those defendants. The court satisfied C would obtain judgment against at least one of the defendants, but the court cannot determine which, and all the defendants are insured, the MIB or a public body. We had this very instance in the case of Arshdeep, case that I'm involved in, being led by Chris Melton on. And this is a case at a construction site. The main contractor argued that we were bound to succeed against the employer, and therefore this was a 25.71C case. And if I just go back to that to remind you, 25.71C, so the court can make an order if satisfied the claimant would obtain judgment against the defendant whom they're seeking an order. And so the main contractor says, well, you're bound to succeed against your employer in this case. It's a classic 25.71C case. So why are you bringing in all of these defendants to seek an interim payment order against us all? 25.71E isn't that type of case. It's reserved, they said, for the classic whodunit type of case. So a case where you know that the claimant was employed by somebody, but the two defendants or the three defendants are denying that they're the employer, and they're each saying it's the other defendant that's the employer. They said that's a perfect case for 25.71E. You know you'll succeed against at least one of the defendants as the employer, but you don't know which one the employer is going to be yet, and you can't determine that till after trial. And the Court of Appeal said no to that. They said that in these types of cases, we're going to give a broad interpretation. So it will work on those cases where you've got defendants all denying that they're the employer. It is applicable to those, but also it applies to the other circumstances. You know you will succeed against D1, they're your employer, but you don't know whether you're going to succeed against D2 or D3 as the main contractor. It's applicable in those cases because you know you will succeed against one, you can't determine whether or not you'll succeed against the second or the third defendant. So the Court of Appeal gave that a wide interpretation and rejected the narrow interpretation that the main contractor was seeking in that case. Okay, the final limit of 25.71e requires all of the defendants to be insured, and the court had to consider in an earlier case whether it should give a narrow or wide interpretation to that particular subparagraph. Is it all of the defendants in the case have to be insured, or just the defendants against whom you're seeking interim payment case? This was another Chris Melton case, and on this case, the Court of Appeal gave a narrow interpretation to the rule, and they said it's just the defendants against whom you're seeking an interim payment order that need to be insured. So that almost deals with 25.7, because of course there is the point, what does insured mean? And in the Butter Arshdeep case, a number of the defendants are reserving their indemnity position. And so one of the arguments deployed in the Court of Appeal was that, well, we've reserved our rights, therefore we shouldn't be ordered to pay, or the other defendant shouldn't be ordered to pay the interim payment because we might not be able to adjust between us. And it may be that one of the defendants will have made a payment out and not be liable at the end and won't be able to recover the money they've paid out from the defendant. And the Court of Appeal said, no, insured means just that. A reservation of rights, indemnity issue doesn't mean that D's not insured. That rather begs the question, what if the defendants go one stage further and purport to avoid the policy of insurance? And of course, that begs the question then, does it matter if the insured or the claimant then tries to contest that and says, well, the insurer can't avoid the policy because it's not been breached? How's that resolved? And the Court of Appeal indicated in Arshdeep that the insurers could join themselves under the Gertner and Circuit principles to ventilate all of those arguments in an appropriate case. Right, that brings us to, if you like, to the end of those sort of condition precedents, and we come to, I suppose, arguments that might revolve around the valuation. And you'll all be familiar with subparagraph 4, the court must not order an interim payment of more than a reasonable proportion of the likely amount of the final judgment. Eales and Cobham Hire Services Limited is the case, and it's well known. I'm not going to set it out at any length, just going to identify some principles for you. So, reasonable proportion of the likely amount of the final judgment, that's a conservative basis. A reasonable proportion may be a high proportion, and the object is to ensure that the claimant's not kept out of money whilst avoiding any risk of overpayment. And those are the broad principles from Eales. So there's obviously discussion about the likely amount. It's the likely amount of the capital sum, not the capitalised value of the PPO. There's got to be care not to fetter discretion, care not to establish a status quo, care not to create an unlevel playing field. And you can see that all of these headings, if you like, are fertile ground for arguments. We're going to have a look at some of those in a moment. So the first stage is obviously the assessment of those heads of loss that the judge is bound to award as a capital sum, their general damages, past losses, and interest. And accommodation costs are usually to be included because it's very common indeed for accommodation costs to be awarded as a lump sum. So does that mean that in all interim payment applications, where you've got a claim for accommodation, and you're effectively claiming for that accommodation, are they bound to succeed? And of course, the answer's no. Azam and Valley is an interesting case. This involved David Allen, King's Counsel, sitting as a Deputy High Court judge, Winston Hunter, KC for claimant, and Darrell Allen, KC for the defendant. The claimant had spent about £225,000 on past accommodation costs and claimed those. It's about £50,000 rent and about £175,000 on works to a property. That property was owned by the litigation friend, and it required to be purchased from the litigation friend at £173,000. And the Court of Protection had given permission for that to occur. And it required a further about £400,000 worth of work to be done to it before it was completed and ready to be used by the claimant. The defendant contended that that property was not a reasonable property for C to purchase. The defendant disputed the scheme in its entirety, and they disputed the reasonable cost of the scheme. So all those 3 points in issue, whether it was a reasonable property to purchase, whether the scheme was reasonable, whether the costs were reasonable. Now, the litigation friend had also purchased an alternative property that was almost next door or behind the property. And that property could be adapted for the cost of £150,000, according to the defendant's expert. And the defendant contended that that property was a more suitable property for the claimant. So those were, if you like, the accommodation issues. There was a further complication because this was a short life expectancy case. And it was argued, therefore, that the principles in Swift and Carpenter did not apply because the Lordship said in that case that these principles may not be applicable to short life expectancy cases. Mr. Allen, having listened to those arguments, held that the issues raised by the defendant in respect to the accommodation claim, both past and future, are ones that could only be resolved at trial after the hearing of evidence, lay and expert evidence. And whilst he was satisfied that there would be a substantial award in respect to future accommodation costs, he felt unable to go beyond the figures advanced by the defendant. So I think it's a good recent example to show how accommodation claims can be disputed. And if there is evidence deployed, and in this case it was deployed by way of an accommodation expert, I think there was a draft care report, and if all of that evidence is put before the judge and raises legitimate factual arguments and additional legal arguments, then it becomes difficult for a judge to include all of the accommodation costs that are being sought. So whilst usually included, there are still arguments that can be deployed on both sides, either in favour of or to resist these types of claims. If we're looking at past losses, then of course it's usual to assess those to the dates that the interim payment is being carried out, or the application is being carried out on, because those are the past losses to the date of the assessment. And Amanda Yip had to consider these issues in the case of Powell and Davison. This was a case involving William Latimer Sayer, King's Counsel, and I actually appeared in front of Master Eastman against Mr. Latimer Sayer on a case fairly recently, and Master Eastman kept referring to William as Mr. Latimer Slayer, which kept making me chuckle when he was calling him that. He didn't slay me, I'm pleased to report. I'm still here, alive and kicking. So in Powell, Amanda Yip had this to say: it seems to me that the starting point remains as stated by Smith LJ, that strictly speaking, the court looks at special damages to date. However, there will be many instances where it is entirely appropriate in making the conservative assessment at the first stage to bring in special damages which have not yet accrued, but will do so before trial. I consider this as a question of fact, which inevitably depends on the context of the application. When considering an application for an interim payment to cover the claimant's pre-trial needs, it may well be reasonable to include costs which are yet to be incurred, but which will accrue before trial in the stage 1 assessment. Whether it is reasonable to predict the cost of trial or for a lesser period must depend on all the circumstances. There is a balance to be struck. The risk of possible overpayment must be managed, particularly where any uncertainty exists. On the other hand, the claimant should not be kept out of her money and not be required to make frequent applications for further payments. And so the date of assessment, not just to the date of the interim payment application, but can also include costs going into the future up to the date of trial. And that, of course, begs the question, brings us to our next slide. What's the date of trial? And His Honour Judge Bird, sitting Stepney High Court judge, had to consider just this in the case of Knight and White, and this is a James Rowley case. James Rowley Casey acting for the defendant here. And the issue was directly addressed in order to assess the losses between the date of the schedule and the date of trial. The first issue to determine is when the trial is likely to start. There was some discussion about how I should determine the question, and in particular, if I should take a conservative approach or put myself in the position of a hawkish judge listing the matter for the earliest possible trial date. In my judgment, I should simply do the best I can to say when the trial is likely to take place. It is artificial to expect me to adopt an overly hawkish approach, just as it is difficult to adopt a conservative approach. The concept of a conservative approach is easiest to grasp when the court is being asked to assess what level of damages might be awarded in the future on the basis of evidence that is not yet fully formed and where there are well-argued competing positions advanced by each side. Applying a conservative approach to the question of when a trial is likely to take place is less easy. So Judge Bird did the best he could in those circumstances. But the listing of trials is inherently uncertain, isn't it? Should the judge do the best he or she can? I think the trial will be listed in 12 months. There's a responsibility applying EELS to avoid the risk of overpayment. So would a judge be better to say, well, the trial could realistically be anything between 9 months and 24 months, and therefore to avoid the risk of overpayment, which we're required to avoid according to EELS, I should adopt 9 months. I don't know. Judge Bird didn't agree with that approach. He just adopted the figure that he thought was accurate. But I think there's room to argue the point in front of a different tribunal, perhaps. That brings us to the question of conservative valuation, I think, and what that then means. Many interim payment applications are contested or concerned with competing valuations of the claim. And we're just going to look at a few cases. The one on the screen now, Granger and Cooper, that's the standard view, where you've got a fully reasoned counter schedule. The interim judge can't really make an assessment of the strengths or otherwise of the rival contentions, and therefore the figures adopted by the defendants are often used or seized on by the judge. Moore is a case that follows Granger and the judge in this case felt unable to ignore medical evidence served shortly before the hearing, and he treated the defendant's valuation as the irreducible minimum. That's the minimum level of award that the claimant would get, and therefore he based the conservative valuation on that. Barrington Menzies Haynes is a more recent case. Rhiannon Jones, KC in Chambers, appeared for the defendant on this case in front of Mr. Justice Martin Spencer. And he held this: the objective of an award of interim payment is to ensure the claimant is not kept out of his money to which he's entitled, whilst avoiding any risk of an overpayment. Thus, where there are genuine and substantive challenges to causation, in my judgment, the court cannot award damages by assuming, whether on the balance of probabilities or otherwise, that the causation issues will be decided in favour of the claimant. There is and remains such a significant gap between what the claimant is seeking and what the defendant is conceding that were I to accede to this application, there would be a real risk of an overpayment. Even that states the position too highly in favour of the claimant, because it is not just a real risk that needs to be avoided, but within the authority of Eales and Cobham, any risk which needs to be avoided. And so that might be the high point of the argument that defendants can advance in these cases. If you've got to avoid any risk of overpayment in accordance with the authority of Eales and Cobham. Well, if that was the high point, then in this case of Jolly and Champion, a recent case, December of just last year, so a few months old, Chris Melton in Chambers appeared before Her Honour Judge Evans in Manchester. And it was a case where the defendant served surveillance evidence and a letter from one of their experts putting the issue of causation of all of the claimant's ongoing difficulties into issue. And so looking at whether there's a risk of overpayment if the award's met, then your immediate reaction is going to be yes, because if this evidence is accepted by the trial judge, and here we have a Part 35 expert putting these issues into these causation issues into play, then surely the application's got to fail. But Judge Evans was having none of this. She disagreed with Mr. Weir's submission that only if I can reject the letter as patently wrong, only if I take the view that no reasonable judge could accept the letter, can I assess the likely amount of the judgment on any basis more positive to the claimant. Of course, this is an interim payment application, not the trial, and often that will mean that the defendant's position is the one adopted by the court. But the assessment of the likely amount of the judgment must inevitably involve some degree of consideration of the merits or demerits of a particular position or a particular head of loss. If it did not, then all that could ever be awarded would be that which the defendant admitted. In reaching that view, I note that Smith LJ said at paragraph 35 of Eales, we would not necessarily accept that a judge considering an interim payment must always work on the defendant's figures. Sometimes there are good reasons why those figures should be rejected as too low. It is necessary then to consider the letter in some detail in order to decide what weight should be attached to its contents in assessing the likely amount of the final judgment. And the judge looked at the letter. The letter was not Part 35 compliant. No reasons had been given for a very significant change in opinion, and Judge Evans came to the view that that evidence was highly unlikely to be accepted by the trial judge, and therefore she proceeded to reject that evidence and make an interim payment. Okay, once you've got to a conservative valuation, going back to Eales, we know we can make a reasonable, or the claimant can have a reasonable proportion of that. And we know from Eales, they said it can be a high proportion. I've cited here the case of Alan A. So again, it's a recent case. It's in front of Mr. Justice Robin Knowles, and Winston Hunter Casey was for the defendant on this case. And the judge said the result of the various arguments is a conservative total of £850,000. As Eales makes clear, a reasonable proportion may well be a high proportion, provided that the assessment has been conservative. In my view, a reasonable proportion in the present case is £800,000. We're going to come back to Al and A in a moment. So purpose is something that's often included in claimant witness statements. Sometimes the purpose is queried by the defendant, and Eales suggests that the court will not normally have regard to what the claimant intends to do with the money, unless it would create an unlevel playing field, and then it's relevant but not conclusive, because it's the claimant's damages and the claimant's free to spend as he wishes. But I refer you back to Powell and Davison, Mrs. Justice Yip again, and the William Latimer Sayer case. So the claimant's counsel invited the court to include all the likely costs to trial in the stage 1 calculation. And Amanda Yip said, if the court brings in the likely costs of care and other needs to trial when addressing Eales stage 1 in relation to an interim payment which is expressly sought to meet the claimant's accommodation needs, difficult issues may then arise further down the line. The court must guard against allocating large elements of other pre-trial expenditure into an interim payment for accommodation. That is not to ignore the guidance of paragraph 44 of Eales, that the judge need have no regard to what the claimant intends to do with the money when addressing the first stage of Eales. Rather, it is a case of acknowledging that the same sums cannot be spent twice. If they are brought in at this stage and relied upon to found an interim payment, which is then used to fund accommodation, they will not later be available to fund care and other needs. In those circumstances, it seems to me that I must leave out of account the special damages which are likely to accrue in relation to the claimant's other needs when considering this application. Doing so will avoid prejudicing future interim payment applications and or the availability of funds to meet the claimant's ongoing care and rehabilitation. So it's a really interesting decision. It's a judgment that's well worth a read, and it begs the question, do you, in your statements in support of your interim payment applications on behalf of the claimant, say what you want the money for or not? Do you include care costs and other needs or not? Can the claimant say, well, they should be included, and if the claimant wishes to spend money on other things, well, the claimant's entitled to do that. And if that means the claimant's owing to the case management company, that's the claimant's lookout, and the claimant can fund in other ways, you know. So all those arguments suddenly come into play. Or can the defendant say, if the money's spent on accommodation, then it's not available to fund care, and therefore care will either not be provided, in which case it shouldn't be included at all, or the judge's discretion as to future PPO is fettered. So one can see that the arguments that Powell's thrown up are many, and it's a fertile ground for argument in future cases. And I'm just surprised that in light of the guidance in Eales and what Yip said in Powell and Davison, that there aren't more cases where this very point is being argued. Maybe they are being argued, maybe they're just not reported yet. So what defendants have been arguing for a while is status quo and unlevel playing field. These are the standard white book cases. Experience tends to suggest that these arguments aren't very attractive to judges. They take them into account when exercising their discretion, but as per the last case here, Granger and Cooper, trial judge isn't really going to be influenced by these sorts of arguments. And that tends to be the line that judges, in my experience, have taken in these sorts of cases. In the case of Selwyn and Shahid, again, it's a recent case just last year, defendant argued prejudice. This was a Winston Hunter case. He was appearing before His Honour Judge Pearce, and Judge Pearce said this: the first issue to consider is whether an interim payment should be refused because of the level playing field argument. The concern expressed by the defendant is that this interim payment is intended to be used to continue to fund a care regime, which is simply beyond what the claimant needs, but more significantly is likely to hinder rather than help attempts at rehabilitation. The former point simply goes to the quantum of any order. The court should, on the defendant's argument, exercise particular caution in valuing the claim where there is such a discrepancy of opinion between experts. But the latter point goes further. As I've noted, Dr. Crawford's comments, I am concerned that the support is being used to provide company and will result in learned dependency. If she is correct in this regard, then an interim payment at the level sought by the claimant will not simply be an overvaluation of the claim as it currently stands. It will lead to a position where the claim may increase in value because of the consequence of the learned dependency. Against this, though, must be weighed the argument that if Dr. Crawford is incorrect, and if in fact the claimant's case correctly identifies his reasonable needs as including care at the level now being claimed, he would suffer prejudice as a result of not receiving appropriate care and therapeutic input pending a trial that may be 2 years hence. This prejudice is at least as great as that which may be caused to the defendant. In my judgment, this argument should not lead to a situation in which the court declines to make an award for an interim payment at this stage. However, it remains relevant to the exercise of the appropriate caution under the yields test as to the amount of any award. So here we've got the defendant saying, well, we've got an expert saying that this regime's wrong and it's too expensive and it's going to prejudice us. And the judge saying, well, I'm just going to take it into account when I exercise my general discretion. And that's a really different approach compared with Mr. Justice Spencer in Farrington, where he held if there's any risk of overpayment, that's to be avoided. So you've got judges approaching these sorts of issues in very different ways, it seems to me. So we can move to look briefly at the second stage. Elements of future loss may be included, but only if there's a high degree of confidence that the trial judge will award capital sum and there's a real need for it. So second stage feels, and we go back to the case of Alan A. I said we'd look at it again. Again, it was Winston Hunter, and it's interesting because although the Court of Appeal in Eales allowed future losses in stage 2, subject to those principles, those tests that we've just looked at, it was again argued in Alan A. And I'll just read part of the judgment to you. Mr. Hunter QC's first argument was that there was no jurisdiction to order the interim payment sought. I consider the jurisdictional limit is that set by CPR 25.74, a reasonable proportion of the likely amount of the final judgment. This does not say that future losses cannot in any circumstances be considered. And despite the terms of paragraph 31 of its judgment, when read as a whole, the Court of Appeal in Eales does not suggest as much. The Court of Appeal's guidance goes instead to the exercise of discretion in accordance with principle. The distinction is important. If future losses were to be placed outside the jurisdictional limit, then in vital early years after an accident, but at a time during which litigation is not being taken to a conclusion, in the interest of allowing a more informed prognosis, less may be available to achieve important rehabilitation ends than is desirable, always ensuring fairness to both parties. And so having considered a conservative value to be 850, a reasonable proportion of that to be 800, Mr. Justice Noel said this: but over and above that, and if the figure I have taken was to be regarded as too high, the Court of Appeal in Eales recognised that there are circumstances in which the judge will be entitled to include in his assessment of the likely amount of the final judgment additional elements of future loss. That can be done, said the Court of Appeal, when the judge can confidently predict that the trial judge will wish to award a larger capital sum than that covered by general and special damages, interest and accommodation costs alone. There must be a real need for the interim payment requested. I must be satisfied to a high degree of confidence that expenditure of approximately the amount to be awarded is reasonably necessary. And then the judge found he was so satisfied. Although the Court of Appeal made clear, I do not need to consider whether the particular house proposed is suitable. That is a matter for the Court of Protection. I am still required to decide whether expenditure of approximately the amount proposed to be awarded is reasonably necessary. I am so satisfied to a high degree of confidence. This is because it enables AL to have the continuity, stability and security of her existing home and school and carer arrangements, and these are central to her rehabilitation, development and to any chance of a good prognosis. There are serious potential adverse consequences involved in the alternative of requiring AL to leave her home. I recognise I am encroaching on the trial judge's freedom to allocate between an immediate capital sum and a PPO, but I am prepared to predict that the trial judge would take or endorse this course. Again, I do so with a high degree of confidence. So the defendant's arguments that you can't include future losses were not accepted. They can be included. The Eales, second stage of Eales test was, of course, followed by this judge. He was satisfied that that was the appropriate thing to do, even where he thought that he might be encroaching on the trial judge's freedom to allocate between an immediate capital sum and a PPO. Going to just run through some slides very quickly now. 25.75, the court must take into account contributing negligence. You'll all be familiar with this point, but it's important. Smith and Bailey, the evidential burden is on the defendant when it comes to allegations of contributory negligence. And sometimes this is overlooked by the defendant. So it's incumbent for evidence to be provided in support of this. And if there's a simple defence raising a seatbelt issue or whatever it might be, that's not going to be enough to lead to a reduction for contributory negligence. Okay, I'll just touch briefly on 25.8. That allows the court to adjust any interim payment vis-a-vis claimant defendants or between defendants. And that sometimes, you'll see in some of the judgment, that provides succour to judges when there's a property that can be sold if required. So if there's any risk of overpayment, well, the property could be sold, so the defendant's not prejudiced or the insurer won't be prejudiced. And of course, adjustments can be made between insured defendants without any difficulty. So again, it's another reason for judges to make awards if there are arguments on the edges. So we've looked at some of the points, I hope, here. Who to pursue, the insurance status, particularly relevant when you've got multiple defendants. Do you go against all of the defendants, or just the one you think you can succeed against? Well, I think you go against all defendants, even if you're unsure whether you're going to be successful against all of those defendants. And defendants can't turn around and say, well, you shouldn't be going against me because you've got a cast iron case against D1. That's not going to wash. You can go against multiple defendants where they're insured and you satisfy 25.74 EAD test. What evidence to deploy? Well, we've seen some of these cases failing because although surveillance evidence and a letters deployed by the defendant to resist interim payment application, that's not been good enough evidence. The judge would expect a Part 35 report signed with the statement to the court, explaining their duties to the court, and reasoned, and not simply a bare letter. I've done many cases where there have been bare letters in support from both sides, claimant and defendant, and either in support of the application or resisting the application. And we should just apply a little bit more care to that, because that sort of evidence could be rejected if the judge doesn't want to make the application, or they do want to make the application. So think about the evidence that you need to deploy, whether it's from your seatbelt expert to show that the seatbelt wasn't being worn, or whether it's from your medical expert, and look particularly at the form. Is that going to be persuasive enough to the judge? And once you've considered all of the evidence that's been deployed in this case, are there genuine or substantial challenges to causation? Because if there are, that's going to be problematic for the claimant, and claimant's going to have to come up with some ways to get around that if there are those genuine and substantial challenges to causation. Stage one arguments are all, there's going to be lots of arguments still around valuation. We know some of the rules around conservative approach now in a reasonable proportion, and we've touched on a number of the arguments, but one can see there are still fertile arguments around many of these points. We've looked at the treatment of damages between the assessment and trial, and again, you'd think that was straightforward, but there's arguments about, well, when's the trial going to be? Should we include all of the past losses, or should some of those past losses be excluded because they're for a particular purpose? Then that might go back to what evidence you deploy by way of your witness statement, whether you say what the purpose of the interim payment is for. And of course, issues about contributing negligence we've just touched on. Stage two arguments, there's the treatment of future losses, and there's the issue of need, or the question of need. And again, in stage two, you're going to need to show that, and so the purpose of it really does come into play. And so I suppose if you're in a case where you might be looking at a stage two argument, if you're on behalf of the claimant, you're going to have to say what the purpose of your interim payment is, because you're going to have to demonstrate need. And then that automatically exposes you to arguments, well, some of those past losses should be excluded because they're for defined purposes, and they shouldn't be brought into account if this is an accommodation claim. So I think those are some of the points that arise. I've set here just a couple of thoughts about future points. The first is a really technical argument. What if the defendant's insured, but the insurer says the policy's been avoided? I think we touched on that. There's an even more technical point to do with the insurance position. So there are points around insurance and multiple defendants and so on, which are yet to be ventilated. I wonder if there was a pre-action interim payment scheme, whether that would be attractive, whether anybody would want anything like that. They're not matters for me. I just wonder if there's an appetite for that. Possibly not. And then could I perhaps leave you with this thought? This talk would not have been possible without reference to all those reported decisions on part 25.7 and all of those cases where big interim payments have been made, contested, and then made. But 25.9 says the fact of an interim payment, the fact that an interim payment has been made, shall not be disclosed to the trial judge until all questions of liability and the amount of money to be awarded have been decided. So does the reporting of a decision mean it's disclosed to the trial judge? You might say, well, no, not really. But what if it's widely reported? So in my case of Arshdeep, I appeared on a interim application after the Court of Appeal, and Mr. Justice Turner said, well, I'm familiar with the decision of the Court of Appeal in your case, Mr. Lemmy, so I can't deal with this case as the trial judge now, can I? Because 25.9 and the defendant hasn't agreed to this. And so there's a point there. And how is it that all of these cases are being so widely reported when we have Rule 25.9 that tends to suggest that these decisions shouldn't be disclosed? So that then brings to the end of my talk. I think we just heard, or certainly I'm hearing someone else's voice over me. Thank you for attending. We're slightly less than the time we allocated for this, about 50 minutes or so. Thank you for your patience and for bearing with me. And as I said, the handout is on the, or the PowerPoint is on the chat button should you wish to download. Thank you very much and look forward to meeting some of you soon.